Okay. Live? Okay. All right, good morning, everyone. I'd like to call the Will County Board Executive Committee meeting to order at 10:25 a.m. Let me see here. Marcy, would you like to lead us in the pledge, please? To the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, Marcy. Jackie, can we have a roll call, please?
Richmond. Williams. Butler. Butler. Freeman. Hickey. Logan. Newquist. Ortiz. Ortiz. Pretzel. Trinier. Van Dyne.
Present.
You have a quorum.
Thank you. We have 3 sets of minutes to approve. Looking for a motion to approve the Executive Committee Board Agenda Setting Meeting, April 10th, 2025. Discussion? I have a discussion item. Member Hickey?
Yes, I believe on page 9, there's a Scrivener's error that refers to Ms. Newquist as Mr. Newquist. So
Okay, typing error.
I'm sorry.
Does there need to be a motion to have that change? Scribner's error? No, okay. Nice. Page 9. Very good. Thank you. Any other comments or discussion? Can we have a roll call?
Richmond. Williams. Butler. Freeman. Hickey. Logan. Newquist. Ortiz. Pretzel. Trinier. Van Dyne.
Yes.
Motion passes.
Thank you. I guess this question is for the state's attorney. Does that constitute a yes? Okay. All right, looking for a motion to approve the Will County Ad Hoc Access Will County Committee Special Meeting, February 11th. Discussion? All those in favor, please say aye. Aye. Anyone opposed? That motion will carry. And the last set of minutes is from the Ad Hoc Old Courthouse Committee Special Meeting, February 11th. And seconded by Freeman. All those in favor, please say aye. Aye. Anyone opposed? That motion will carry. Perfect. Under old business, review updated chapters 10 and 30, and I would like to have turn this over to Member Chenier, Chair Chenier, and Mr. Mock. Is he here?
I didn't see him.
Okay, Ms. Chenier?
Thank you,
Forward,
Chair
please.
Van Dyne. We went through these 2 chapters because of, actually from the eagle eyes of Mr. Richmond, caused us to go back through these, and we actually found a number of different things that we needed to change. And I think they are now ready for final approval for the second time, or maybe the third. But they are ready.
Okay, great. Sounds like we're making progress, which is good. Thank you. Any other comments on old business? Mr. Butler?
Yeah, for some reason, nothing is matching up here. I don't have any of the minutes on my, my screen here on my agenda for what was loaded. I don't know why. And then my chapter says 10 and 25 or something, so I didn't, oh, there it is, up there. Okay.
My agenda
10 and
looks
25, that's the same, but for some reason, when I click.
10
the
and 30.
minutes, it comes up. Yeah, that's all right. I did, I didn't vote on the minutes because I was too busy, trying to, what?
Okay,
And my iPad's dead, so I didn't realize they weren't coming up, but I have the written copy here and it looks like they're okay up there.
well,
I guess
we
I'd like
we
to
just
be
got,
abstaining from those since.
well, I don't
didn't
think
see 'em.
I didn't mean to interrupt, but I don't think we're voting on that. It was just a simple update
Mhm.
for the, oh, okay. Do you want to be, is it too,
You know what? And it's different on the printed agenda, just FYI. On mine, under old business, there's a number 1 and it says review updated chapters 10 and 30. And that's all that it says. Up there, it says the ordinance printout and then it has an A for chapter 10 and nothing about chapter 30. So that's just kind of strange.
I'm seeing what's up there.
Yeah, no, I'm assuming that that's the webpage.
You want to,
I'm just telling you about the printed.
I think there might be an explanation.
Screen are just the hyperlinks to everything. That's why it's going to look different than the printed hard copy
Okay.
agenda.
But Dan, are you referring to the 3 previous approval of minutes?
Yeah, yeah.
Okay,
Sometimes, I don't say nay, but, I just wanted to maybe abstain for those
Okay,
since I
can-
can't read them.
it'd be on the record that Mr. Butler abstains for the 3 votes on the minutes. Thank you. Okay, thank you for the update
Mhm.
on old business. There is no other old business.
I
As far as I know.
I have a question.
Pardon? There's a vote on the review updated chapters 10 and 30?
Yes.
If you click the printout, it doesn't show anything.
Yeah, the ordinance printout on number 1. Again, my iPad isn't working, but. Yeah, it goes to minute track, only without the M and without the AC. Are the chapters there?
Yeah.
Both of them? That's chapter 10,
Chapter 10.
right. Man, we got to get this system fixed.
I am not an IT expert, but sometimes I feel some folks are logged in and some are not. I don't know if that has anything to do with it. All right.
I just looked at the link that you just clicked on, chapter 10 and title 3, chapter 30. And yeah. Yeah, that's,
Sherry,
If you click on review updated chapters, number 1, it'll take you to
To attend.
the attachments will
Mhm.
say chapter 10 and chapter 30.
right. That's what I did at home and it worked out fine. But
They're on that
the agenda seemed kind of odd that it only had 1.
one. I could get to it like that.
Mhm. That's,
okay.
that's what I did at home.
Is this committee okay to move forward then approving 10 and 30? Okay. Can I get a motion to approve?
Motion, Freeman.
Motion Freeman, seconded by Hickey.
Previous or alternator?
Thank you. Roll call, please.
Richmond? Okay. Williams?
Yes.
Butler? Freeman?
Yes.
Hickey? Logan? Newquist? Ortiz? Pretzel? Trinier?
Yes.
Van Dyne?
Yes,
Motion passes.
thank you. Motion does pass. All right. Pardon?
Can I get a vote count? What was the vote count?
Ten in favor, 1 against. Motion carries. Okay. Vince, did you have, Mr. Logan, anything under other old business? Okay, I might have jumped ahead. All right, so we'll move along. Starting with new business, the county will working with USACE, DuPage River buyouts and engineering work.
Motion, Trinier. Need to put it on the floor, folks.
Second, Newquist. Mr. Radner, do you have a minute to come up and give a brief explanation?
All right, good morning.
Good morning.
The County of Will partnered with DuPage County and the U.S. Army Corps of Engineers to complete the DuPage River feasibility study. So with this work was started in 2015. The report was issued in 2019. And by 2020, the County of Will and the Army Corps of Engineers signed the project partnership agreement. And in that agreement, it laid out the properties that were required to purchase as part of this project. Basically, their purchase of properties is going to remove the structures from the floodplain and floodway, and then, end up reducing future claims filed on those properties because they'll be returned to vacant land or possibly parkland. So earlier this year, we completed the purchase of the 6 properties in Plainfield Township along the DuPage River. And about 2 weeks ago, all the demos were done and the sites have been restored. So they're looking really good. Now that we've completed those 6, there are 2 more properties left to purchase under the current plan. And Army Corps of Engineers is doing additional study on the site in Bolingbrook because there could possibly be additional properties that may need to be purchased in that area, but they haven't determined that yet. And one of the sites that we agreed to purchase initially is on the same property where possibly those structures may be flood-proofed or maybe they will need to be purchased. We'll have to find that out here in the coming months. But we do have one site left in Shorewood. It's near 59 and Jefferson, and that site is in the floodway. It was identified. The owners were given notice that the county does, this is part of the project, and that eventually we will be purchasing that property. Per the agreement, we are required to purchase all properties that are in the floodway. And this resolution that was prepared outlines the same terms that were in the previous resolution that to purchase the other 6 properties. So right now, we're just seeking approval to move forward with the purchase of that property. Correct.
Thank you, Mr. Radner. Any questions? Previous roll? Actually, let's do a clean roll if we can. My apologies. We could, but we'll just do a clean roll.
Richmond, Williams, Butler, Freeman, Hickey, Logan, Newquist, Ortiz, Pretzel, Trinier, Van Dyne.
Yes,
Motion passes.
thank you. Looking for a motion to amend the governance rules and procedures for Will County Board for 3.02 time and place of regular and special meetings. Motion, Trinier. Second, Newquist. This here is basically changing, if you prefer, to change our meetings from 9 a.m. to 9:30. There was suggestions by some of the board members and also, I believe, county board and executive staff that it might be advantageous for us to give them a little bit more time to be prepared. That's why this is on the agenda. Any questions or discussions, Ms. Trinier?
Yeah, because this is a change to our rules, it's 2/3, 3/5. I can't remember the number off the top of my head. What do we have to have at the full to make the change? Yeah, at full board. That's what I meant.
Full board is what? 3/5 at the full board meeting.
Thank you. I couldn't remember the fraction. Thank you.
Any other comments? Ms. Ogala?
Yep, thank you. So that's one of the reasons why I was a no for that, because I know the time that is needed prior to the meetings. So I was a no to going to 9 o'clock. So I'm glad that it is going back to 9:30, because as staff knows and has learned, new staff, all kinds of crazy things happen prior to the meeting, and the little extra time gives them that cushion to get everything set up right in case something happens. So I think it's a great idea.
And this is also a prime example of, taking some feedback and trying different things. And if it doesn't work, to go back to the way it was. And so, any other comments? All right, looking for a previous roll. Thank you. All those in favor, please say aye. Aye. Anyone opposed? Motion carries. Number 3, this is just a discussion. Eliminating public hearings for land use cases at the county board. I believe, wasn't Ms. Tatro prepared to speak on this, but unfortunately she's not here
Joe, I can't address.
Okay. You mind coming up, Kevin, please?
So essentially, this is a policy decision of the board, but neither the Constitution nor the statute requires you to have the two hearings that you do, one at PZC and one at the county board level. It only requires one before the Public Zoning Commission. So that's the short legal answer. What you would like to do is a policy consideration.
Okay, I'll open up the questions. Mr. Butler first.
So who proposed that we remove public hearings from the county board meeting?
I'm not sure. I've only asked the legal question as to once it comes on the committee agenda. I was made aware of it a couple days ago.
Dan, there was a couple mentions from some board members about the length of time that the public hearing takes. And also, if I remember, it had something to do with going out and actually visiting with the constituents and getting their perspective, getting, say, the applicant's perspective on certain projects. And essentially, the board members are not supposed to take any of that information into consideration only during the public hearing that we reside over. And that's not what we want to do as board members. We want to be able to go out and talk to our constituents and try to do our own homework and look at both sides. And I think eliminating the public hearing may allow us to do that, if I am saying that correctly.
You would still have problems with relying on extraneous information, but it certainly could clear up certain things. The record before you would be in front of the PZC. It cleans things up later down the road if you are both doing a public hearing in front of you and you're doing these extraneous things. We still would prefer that you do not, or we can't direct you to do anything, but we would prefer you not to be getting this extraneous information. You should be relying on the PZC record. But that certainly complicates things when you have multiple public hearings going on.
Okay.
So I guess I could see not having multiple public hearings, but it seems irresponsible that the ultimate body that would make the decision wouldn't be present during the hearing. So to have it in a different committee, we would just be taking the words from the other committee, like, hey, they heard this and they said that, they weren't going to allow it. I just think that, we're here to do a job. And if you want to eliminate one, maybe eliminate it from the other one, but certainly not here where we're making the final decision.
So you cannot eliminate the hearing before the PZC. The statute does require the PZC. And I will tell you, it's slightly analogous, but at least in the circuit court, there are all sorts of administrative decisions where the judge doesn't hear the actual evidence. He relies on the administrative record, which is held by, say, the state police or a planning and zoning commission, those sort of things. So it is not, that is a feature of administrative law. But the statute does require that the hearing be before PZC. We have had these secondary ones far before I came here. I believe it was as a convenience and a service to the constituents, was the belief.
So, okay, then I think we have to have two meetings. And I guess the only difference between the judge and us is that we're part of the legislative branch. We actually have to develop, these rules or laws or whatever, and the judge just interprets.
But in your role as in the zoning commission, this is why we've said you're not supposed to gather extraneous information. You're sitting as a quasi judicial body. You're making that determination the same way a judge would, or at least similar to the way a judge would.
You good? Go ahead and turn, I think it won't turn on. All right, I have a list. I do have a list here. If everybody wants to just shut your microphones off, I have quite a few, as I saw them come up, to allow Dan to finish up.
Yeah, so I guess my final word is that I would like to keep public hearings at the county board meeting. I think it's important that we do listen to this and listen to the people and make these decisions and witness all this ourselves. I don't think we need to just continuously figure out ways to make less work for this group.
Thank you for your comment. Like I said, as I seen them come up, I might be off a little bit, but I'm trying. Let's go to Member Trenier and then Mr. Balich.
Thank you, Speaker Van Dyne. My question is, and I can't recall this and my iPad's dead, so I can't bring it up. We don't get the verbatim minutes from the Planning and Zoning Commission, do we? I'm not on land use right now, and I don't recall reading them when I was on land use.
I don't believe. that
I
you
don't
do.
believe we do. We just get their vote, the total.
There is that I think does exist. That would also be a feature that would be changed, is you'd have to have a clear administrative record.
So we would get those minutes.
That would be something the state attorney's office would, I won't bind the office, but I believe we would suggest that, because then you have an administrative record.
And then if
Certainly.
I'm recalling correctly, I don't know if they call it a public hearing, but in land use, we do hear from both sides. If there are residents here, we hear from them. And so if I'm not mistaken, what this advocates for, or what this discussion is about, is eliminating just the public hearing at the full county board.
Yes.
Not any public hearing, because I don't even know if we call it a public hearing, but at the committee level.
So that is what this would do. You do not have a public hearing at the land use.
Committee, right.
Committee.
But we have testimony because
Well,
we have tons of residents that show up.
And that is part of sort of the overall thing that we're talking about here. And then we were talking about last month, I believe, or the month
Mhm.
before, is the only real evidence is the evidence introduced at the public hearing. Those people are subject to cross-examination. There's some basic due process issues there. All of the extraneous things of visiting sites, talking to constituents, listening to public comment are not something you can rely on to make your decision. So to the extent that the public they do have the right to make comments.
Mhm.
You are not to rely on those comments in making your decision.
So we would really be making our decision based on the Planning and Zoning Committee.
Yes, and what they do. And
So, and we have the option to attend those meetings. I've only attended one, believe it or not, in 17 years, but.
And at least the cases that I have litigated with land use, at that point, when we're doing them from the county board public hearings, your guys' testimony is reduced to a hearing transcript and printed up verbatim. And so my belief is the same thing would be done with the PZC. There is the ability to do that.
Okay, because, yeah, I would definitely want to get more information if there wasn't going to be a public hearing at the full board. And I would either attend the Planning and Zoning Committee meeting, because I'm a county board member, I can do that. Can we ask questions at that meeting? Do we have the right to ask questions of any of the people who testify?
You would have the same ability to ask questions or present evidence as the members of the public. The Planning and Zoning Commission would be the adjudicatory body.
Interesting. I mean, I don't know where I stand on this. I'm just trying to
And we can
really understand what the process would
and
be.
I can look back and do the research and see if there's any other counties that are handling that a different way. But usually the work is done at the Planning and Zoning Commission.
It makes sense. Why make the parties go through it twice? So I kind of get that. All right, thank you.
Thank you. Mr. Balich?
Yeah, I look at this as impeding the public from actually having a voice. I don't understand why I get it. People don't want to sit here for 3 hours like with the Muslim cemetery, with the quarry, with 143rd Street. Well, we took away the right of the people to have all their emails read into the minutes at the full county board meeting, so everybody could hear what they had to say. Now we're talking about removing their right to speak at the county board meeting. Now, despite the time it takes, they have a right to speak at the county board meeting. And what they're going to come in public comment and talk for 3 minutes after we vote? Is that what's going to happen? Or are we just going to say you can't talk anymore? So to me, it's like, it's the wrong thing to do, to remove the right of the people to actually express their feelings, even though there's a lot of them. The more people that come, the more the county board recognizes the fact that there's a problem, because there's a disparity between who is doing what. The county wants this. This is what the people want. So we have to know that. And the more people that come, the more recognizable it is. So I think it's hurting us as county board members from not having a public hearing. So if we remove it, how do you explain that to people that are very frustrated? And you can go through all of them. The people from the Muslim cemetery, the people from 143rd, the people from the quarry, those are the latest ones that we've had. We've had other ones in the past. So they're not going to go away. They're going to keep coming. And I don't want to be, I'm not going to be voting to remove that, but I don't know what the rest of the board will do, because we've already done it in the board level to remove public comments by emails, be read into the minutes. So I don't know what, it's just wrong to me.
Just for clarification, I do believe that the public has an opportunity to speak at the beginning of the meeting for agenda items. So if they are passionate about an item that's on the agenda, they do have the option to speak. I think just they're not able to be cross-examined by
So
the attorneys, the petitioner, et cetera, et cetera. So we're not really taking their voice away.
But that's still a little bit different, because at the public hearing for the actual case, this one's really important,
Okay.
because like Jackie was bringing up, they ask questions.
Yeah.
We can do a lot of different things at that public hearing, and I think that public hearing is very, very important.
I just don't want the public to think that they don't have the option to speak. They have two different options to speak.
Right, but you
One
know
at the
what's
beginning.
going to happen? People are going to feel like they got their right to speak removed if you get rid of the public hearing. period.
Understood.
So to me, it's totally off limits to do.
And I just want to clarify one last time, like, to Member Butler's point earlier, when we were talking about they're not acting as judges. When you go into that public hearing, your role changes. You are sitting as a quasi judicial body. You have to make certain decisions based on the things that are in your ordinance and state law. The public comment portion is outside of that hearing. It is not evidence that you can consider as part of the public hearing process. With regards to that, there are due process rights afforded to the landowner. There's, as Joe said, the ability to cross-examine. There are all sorts of things. So those public comments in say a finance scenario, they can be counted in how you vote. You cannot look at those public comments during your decision-making process for a land use case. Only the evidence that is produced in the public hearing. And we do read that warning out every time we have a public hearing, that no new evidence will be introduced outside of the public hearing. So
The question for you then. So during the public hearing, that's what we're supposed to make our decision on. And if we don't hear all the residents talking about what they don't like or what they like, how do we make a proper decision? If it didn't come up in the land use or at planning and zoning, then we don't know it. And a lot of people plan on coming to this stuff. So, I mean, you're kind of like contradicting the whole idea.
I'm not advocating for one position or another. Again, this is not a legal issue for the state attorney's office, other than what I've said is that you're not legally or constitutionally required to have the second hearing. What should happen, if you're making that decision, is that evidence should be produced at the Public and Zoning Commission if you go with this system. That is how that works. I don't know how to deal with your specific issue of that you wanted to bring up a question other than remaining with this system. But as a legal matter, the record would be set at the Public and Zoning Commission.
When you talk about due process, the question I have then, you mean due process denies the people the right to speak at a public hearing at the full county board that's going to vote?
That's absolutely not what I'm saying. I'm
Well, that's
saying
kind of what I'm interpreting. That's why you
the
maybe clarify.
landowner has a property right. It is protected by due process, which is why the hearing is done in the Public Zoning Commission or in front of you. That doesn't create a property right or a due process right for the applicants or the objectors to speak outside of that process. They're getting their right at wherever the place is. It doesn't matter whether it's here or at the Public and Zoning Commission. Legally, it has to be at the Public Zoning Commission as a minimum. If you have it here as well, that doesn't affect their rights. They still have a right to speak at the Planning and Zoning Commission.
But all the votes come from here. So if,
And they,
unless the whole board shows up at planning and zoning, then how do we know what's?
you read the administrative
said.
record. You read the administrative record.
Well,
Okay,
we can go on and on.
yeah, let's give some other members a chance to ask questions, and maybe some of the answers will be presented. Dawn Bullock?
So I'm assuming that the PZC meetings are streamed. Do we have the ability to watch those or are they not?
I don't know that the Public Zoning Commission they're not, okay.
They are not streamed? Okay. Could we have them streamed?
We could go to.
I know we can go to them. That's different though than putting it on a stream. We don't
Yeah.
have the answer.
I mean, if it's up to me, I would make that request. It's probably a very simple thing to do.
Yeah. Okay, so I'm being on land use, I do schedule's not permitting it now, but in June, I'm very much looking forward to starting to go to the PZC meetings that are in the evening, the two a month, correct?
Yes.
Yes. Because I feel like I'm going to get a lot more information, a lot more factual information in real time being at those meetings than during a public comment open hearing, which I'm not really supposed to put into my decision-making process. I also like the idea that they're at night because we have people come for public comment and we have a lot of people say I had to take off work today to be here. And if we can like retrain them to understand that if they have something to say, this is the place to do it, that it would be on public record and be part of all of that. And it happens at night. I would think we could get more people to participate and eliminate the need for yet another open hearing during the day when a lot of people can't come anyway.
Thank you, Dawn. Mr. Richmond?
All right, so it's as clear as mud right now, but I'm going to try and parse this out a little bit. So Kevin, what I'm hearing you say is we can only make a decision based on what we hear from planning and zoning and or land use. That's our factual.
Wherever the hearing occurs.
Yeah.
So,
in a form, wherever formally things occur.
correct, where you open up the public hearing, that is the only, so currently it is both here at the county board and things that are presented at the land use committee, or the public, planning and zoning committee.
Understand. Now, as an elected official, our job is to go out and meet with the constituents and try and hear what they have to say and figure things out. So what you're telling me is I need to partition my brain, which is okay. I understand that. I can deal with that. Just like any other jury would have to do. You may have read something about a case 2 years ago and you're selected for jury duty and your job is now just to listen to the facts and make the decision on that. So I don't understand if we have 2 hearings on it, how that could, be a detriment to us other than some time.
Yeah, and the state attorney's office is not advocating for either position.
Okay. So
That's, and if I wasn't clear at the beginning, that whether you do it or not is a policy decision.
no, I heard you, and that's where I'm trying to figure out is because I know we get bombarded with calls not only from our district, but from other districts when things are contentious. And some of these people are very demanding on wanting to, wanting your time or your attention. And I don't know, everybody on this board, I think, is very conscientious and wants to do whatever they can to make sure that the constituents, not only from your district, but from other districts, get heard. Now, it comes down to is you make your decision based on the information that you hear within the confines of these walls, as per se a kitchen table or something like that. And so what you're telling me is if we follow those guidelines, there is no ramifications to us as a county and or a board member.
Yeah, as a general matter, I can't think of anything off the top.
Okay, so right now the discussion point is do we want to have 1 or 2 meetings? And there is no real, the only difference between having 1 and 2 is it's taking up a little bit more of our time.
Correct. You create a bigger record and you have more time.
Okay, thanks.
Sherry Newquist?
Thank you. You answered one of my questions, which was what legally is the difference between a public hearing and public comment? And I can't decide which way to go on this, but I do feel that most of what we hear in the public hearing is not evidence. It's comments and personal opinions. I mean, I feel that they more appropriately belong in the public comment section of the meeting, but I don't know how we do that. And, sitting on land use, we do hear all of this on land use. So why isn't there a public hearing on land use? Are those just public comments that we're not supposed to use when we vote?
Correct. So, and as I've been told by other individuals that this is sort of an anomaly, that a lot of municipalities and counties don't do this. But the Planning and Zoning Commission is the only one that's required. The land use, I think really the point of the committee is to do the work that most committees do. Hey, we want to know all these things, or at least we want to get a preview of what's coming to us 2 weeks later. So I think that is really the work. The public comment is just a factor of that people come to make public comments. It's it's a feature of the system of any public meeting. And I don't know that every agency has a land use committee or so it's just a feature of the Open Meetings Act rather than this specific land use issue.
Because the one issue with public hearing is that the information that we get at the board meeting and then we vote on it, we have absolutely no real time to check it out independently. I mean, we have no time to consider it or look at other information. I mean, if it's new information that's being presented at that public hearing, we don't really know the validity of it. So, I mean, I don't know what the answer is, but that's one of the issues I see with that. Thank you.
And that is part of the process of the objectors and the proponents bring evidence back and forth, just like, and again, I'll use the thing, U.S. sitting in a quasi-judicial fashion. A judge doesn't have the opportunity to go and do an independent fact gathering to see who's right. He relies on the parties that are before him. It's unfortunately a problem, and you have to determine the trustworthiness of the people that are before you based on what you're hearing.
Thank you, Sherry. Chuck, you want to chime in for a sec?
Yeah, I just think, just to kind of clarify where this issue kind of stemmed from, following the hearing on the quarry, I think there was some confusion about what county board members, what kind of research, independent research county board members could and could not do with relation to, some of these land use cases. I think initially there was this belief that if we eliminated the public hearing during the county board session, that it would free up the county board members to be able to go out and do independent research with constituents that they could take into consideration. Subsequent to that, we learned that that is not the case, that eliminating the hearing will not be a corrective with regard to that. So, but again, we were still bringing it up as far as like this being a duplicative hearing. I should also say that the state's attorney's office is going to be here on Wednesday of next week. That's May 14th at 10 a.m. for a committee of the whole to do some extensive training with regard to this specific issue and some FOIA-related issues as well. And that'll be in this, in this boardroom also, so.
Thank you for that. I have Kelly Hickey next.
Thank you. Kevin, can I just ask, I'm really trying to wrap my brain around this. So this is an unwieldy process and it sounds like there are 3 different junctures where the public can have, well, I guess 4 actually, different junctures where the public can have input at the PCC meeting, at land use, at the public hearing, at the full board meeting, and in public comment.
No. So currently as it exists in the system, there are 2 places where the public's comments can be legally considered for determination of the factors under the zoning ordinance. It's at the PZC meeting during their public hearing and during the county board meeting during your public hearing. Those are the only 2 places you can get it. And as Member Richmond put it, sort of splitting your brain here, you may have all these things that are coming out there. People are calling you. People are getting up here during public comment and saying, we absolutely don't want this. If they don't speak during the public hearing, for the purposes, and I want to be very clear about this, for the purposes of reviewing the zoning decision, it's as if they didn't speak. Because you can only look at what happens in the public hearing. You're certainly, they have a right to speak during the public comment, but when the court, and here's the real end game of all this. When a case goes to court, and each one of you is deposed or a certain member, and they say, well, what did you rely on? And if the answer is, we had 500 people in public comment say, I didn't like it. The legal answer to that is that wasn't evidence before you. So the 2 little buckets that you have right now where you're making the decision is the PZC public hearing and the county board public hearing.
Okay, so that's for the purposes of actually deciding what is land use voting on then when they vote on these?
It depends on what is being brought forward, and the land use division would be better to explain to you how different processes come forward. But they are essentially just moving things to the full board like any other committee.
Okay, so they're not, I mean, it seems that the discussion is whether they, endorse the project or do not. And so it's a little bit confusing because if it's just a procedural thing to move it onto the full board meeting, it seems like the discussion takes a different turn.
Sure, and we're going to be doing, like as Chuck said, a full training this to go through the different flow chart of where a variance goes, does how it makes its way through. And the only reason I say is it's just a process of moving it forward. It's not just an administrative step. It depends really on what happens in lower levels of the flow chart. So rather than sitting here and explaining the whole land use process, it really depends on what type of thing is being brought forward, what type of action is being looked, and how it was dealt with at a lower level. So we certainly we'll be able to explain that all to you next week, and rather than focusing on that.
Sure. I appreciate that. I just wanted to say that I think that I was kind of pushing for this because of the possibility of getting the ability to talk more freely with the petitioners that come forward, because that is their expectation. If I say I can't do that, I mean, I know I do like to play Nancy Drew a little bit on my own, so I do like to go and see the properties and see what's going on. But I would just want to make sure that, I'm following what I need to do in order to make sure that if we do get to the point where there's a deposition, that I have used the right information to make my decision. So I think that I'm kind of backing away from supporting separating this out and taking this away from the full board because, like I said, I was hoping to get that relief to be able to do that freely, and it does not sound like this will give us that possibility. So thank you.
Welcome. This topic did come up in leadership meeting. So I would like Jennifer, our county executive, to be able to jump in, and you had something that you wanted to add before you go.
I know you're going to get frustrated, Mr. Butler, I can already tell, but it does say in your rules that I can participate in meetings. And we did have this conversation at leadership. And I will be very frank that since I walked into these doors and we were having a hearing here at this meeting, I've asked the state's attorney consistently, why are we having this? Because this does not happen in any other county in the state of Illinois. Simply for the reason that has been mentioned. A hearing is the official process. So if we do have something that goes to the courts, we have something concrete to go back to. What we have now created is 2 opportunities, and we're seeing this now as we're getting asked for our emails and our texts, because lawyers are going to try to determine if we took outside information and made our decision or inside information. Now, I'm going to, and as we all do, we disagree with the state's attorneys sometimes. And, you know, I am going to say, as someone who's been in the legislature, I am always going to say you should talk to your residents and hear their opinions. But as we know, a lot of time it is opinions. We hear their motions. And remember, when you are at a hearing, the applicant has a right to ask every single question to somebody who comes up here. So technically, that applicant could have asked, you know, the young 3-year-old who gave her speech questions. Now, would they do that to be a jerk? No, that would look bad on them. But that technically is what they are allowed to do. It does not take your ability away to ask questions. I'm also going to say, when I asked why it came here, we have no answer other than, you know, no real answer why it is. We do have a PZC meeting, and I know there's a lot of people who are interested in what I do after hours. You can go to the PZC meeting. It is your responsibility. I'd like to say we've made it convenient for us because we've said it here. We make people take off work and they come to us. Again, if you want to listen to the full picture, you should participate. We see the agenda. You know if it affects your area. So I'm going to, regardless, encourage it. We can put it online as well. But I do think it is a convenience for us. I mean, it doesn't bother me. I'm here all day and I will listen. The biggest criticism I have is I don't smile enough, what I get from people online, but I'll try to do better. But, you know, we have to, again, this is not a time thing at all. I just think it's a protection thing for the county board as well. I would hate to anyone ever feel that they can't talk to their constituents. You have to, like you said, you have to, as Leader Richmond said, you can take information, but you have to, like a jury, you have to just stick with the facts, right? I'm going to, again, what is decided by this. I just wanted people to know that too, I have been asking this question from the very beginning. I feel it's a protection to the county too, as well. If we don't have multiple, I think we have constituents have a great opportunity in land use. Chair Pretzel does allow a lot of exchange as well. So we do, not maybe the official hearing, but again, a lot of question and answer time. I'm going to echo what County Board Member Newquist said, and the fact that I think a lot of the hearing pieces become more public comments because they're just people simply sharing with us that they do not like the project or they support the project, and we're getting away from some of the facts. And as always, just like Transportation Committee, when we have our when the board votes on something, they can ask clarification questions of the staff through the process. So I just wanted to place my blame and why part of this, we're having discussion in this as well. So.
And that truly is what this is just a discussion. It was mentioned by a couple members. And, you know, we all have our beliefs on how we should handle this. So like Chuck had mentioned, we will have a committee of the whole to take a very deep dive into this. And I wanted to bring it up today so we can start thinking about it, write down some questions for May 14th if you're available. This is not going to go away anytime soon. So no vote today at all, but I do have 5 members that have not spoke yet. So I would like to give the floor to Judy Ogala.
Thank you. So a lot of people said a lot of what I would have said is that you as an elected official, you typically go and meet with your resident when they call you because they want you to. They feel very neglected and upset if you do not go and meet with them to see what their issue is. So I understand the public hearing, you're supposed to take whatever's said there into your opinion when you're voting. As far as attending PZC meetings, yes, I guess we could attend 2 more meetings a month that last from 7 till 11 or 12 o'clock at night. We could do that to hear all that. The difference between their board and our board is that they're an appointed board and we are an elected board, and we can also override what they have said. I think the whole PZC process would have to change because often things move from PZC to land use. I don't know that they have time to review minutes within that time frame. And I also, Jackie, have never seen minutes from PZC ever. Never have I seen them. I think they exist, but we've never seen them or have had access to them. And they're never, of course, approved till the next probably month, because I don't know that they can turn around minutes, how fast they can turn around minutes since you meet twice a month. I think that having the public hearing at the full board gives the ability for residents and the applicant, whoever, to be heard by the entire board, because not everyone attends our land use committee meeting. Those of us who are on land use go. I've always gone to land use meetings because since my district is very much rural, a lot of the things impact my area. And some members just aren't able to take another day off to go to another meeting. I guess they could go to PZC, but there you would be speaking only as a member of the public as well. So I support the idea of having this public hearing at PZC for them to make their decision. That moves forward. That decision gets made, comes forward to the land use committee, where we hear that PZC voted 6 or 7 or whatever the numbers are for or against it. And then we take into consideration the information we know. And I don't know that PZC members know nearly as much as we do here at the county board. I just don't know that they do. I don't know how much time they put into researching things. And I don't know if the public reaches out to them at all. I think the public is counting on us. So I support keeping the 2 public hearings as they are. We've done it before. We've had lawsuits before that happened. Over another quarry that happened in, I forget what county board district, where there was Suzanne Hart and Chuck Mayer at the time. So I think it's a good thing to give the public the opportunity to hear. And unfortunately, whatever, these last several years, we've had more issues come before us than we had in the past. And one of the main reasons is because of solar. What the state did, taking away our powers to site, but we still support, pass the special use permit. So it's kind of a backwards kind of thing. But that's what's really driven it up. You have a quarry come up once in a while. Otherwise, you're not hearing that much. So I think it's good to keep both. Thank you.
Thank you. Micah Freeman.
Thank you, Chair. I have written down a couple of questions. So the job of the PZC is to go through all the data and get all the answers. Am I correct?
Correct. Well, yeah, it's a public hearing based on what they get, yes.
And land use attends, I've been to a few. Land use attends them as well. The public is welcome to come. Is that their main role?
Yes, they are the Planning and Zoning Commission to do planning and
Okay.
zoning.
And then our role is just to take that info, maybe question staff, and make a determination based on the facts provided to us, correct?
Well, as it stands currently, you're also taking in the information that you're getting at the public hearing. But yes, you are sitting as a judge adjudicating the facts before you.
So there's a public hearing right now at PZC. Is there one at land use? Because I can't remember today.
Not to my knowledge. There's the 2.
So there's just the one. And we're only required by law to do the one.
The one at the Planning and Zoning Commission.
If we were at a county board and we had a question, could we ask land use and use that as determining factors to our decision?
No, it would be outside the public hearing.
Okay, thank you.
Thank you, Micah. Destiny Ortiz? Okay. Changed her mind. She got her answer. Frankie Pretzel?
Thank you, Chair Van Dyne. So I'm hearing so much stuff, and it's making me think more and more here. I don't know how I feel about all this, but I will say that the current system that we have in place is redundant, and it's also redundant. And What I mean by that is there's this perception versus reality problem of what the public thinks. The public thinks we have planning and zoning, then we have land use, and then we have county board, and they don't know the difference between public comment and public hearing. So they come to land use and they speak their mind. And the truth is you can't unhear what you learn there. I know, we know, this committee, the land use committee knows a lot going into the full board meeting, where the rest of the board knows only what they heard at caucus or if they attended land use. And what I'm hearing from like member Newquist and Hickey, I think is it's not like we want to take away the public's right to come talk to us, but I don't know if necessarily the full board meeting is the right place for that. But land use committee does seem like the right place for it. They're coming anyway, and they're already saying the exact same things that they say during public hearing. The attorneys are here, everybody's here. If we only allowed public hearing at land use committee, it would solve all of these problems. So you keep saying that we're like a judge, but a judge doesn't hear the case and immediately give a verdict. They go into their chambers, they look into it, and or the jury, I forget what it's called, deliberates. And it could take days sometimes before they actually, the challenge we have as board members is these people are here, they're talking, and then we have to vote. And sometimes I want to ask Dan or Judy or Jackie or whoever, what did you think of that? Like, it would make a lot of sense if we had the second public hearing at land use committee and then just voted at the full board meeting. That would give us a chance to have a caucus, to talk to our constituents. Maybe if we're struggling with this, it would really help. So, and then the public, they don't get to have a public hearing at the full board meeting. And the truth is, this could be a disaster. Like, we're not even thinking down the road when we have these modular nuclear facilities that are coming to Will County and how many people are going to want to come talk about this stuff. If that also overlaps with levy votes and things, we could be here for 10 hours. So it makes more sense to take the public hearing away from the full board meeting, give it to the committee. And I think it solves all the problems. And then I look at, like, on the federal scene, we have the Trump big, beautiful bill coming up. Next month, they're going to vote on that. If everybody in America that had an opinion on that went to Congress and talked, we would never vote on anything. Like, it would just take years. So I think that's what's happening to our board. More and more of us are getting our constituents involved, which is a good thing, but it's taking our full board meetings are just, they're getting out of control. If we moved public hearing to land use committee, it would solve, I think, all of these problems in my mind. Like, because the land use committee can't unhear the public comments you can't not take that into consideration when you're voting. You might not like to hear that, but it's pretty tough.
Thank you, Frankie. Last member that has not spoke is Sherry Williams.
Thank you. I'm in agreement with Member Pretzel. I think what I'm hearing is that the PCC meeting is not enough. So we want to the public to be able to participate more than they do. And it's just having that PCC and then we just vote is just not enough. So I think the idea of having a land use committee meeting at the hearing there is a very, very good idea, because ultimately we are the ones that make the ultimate decision. I know I do want to hear what the residents have to say. And sometimes I want to ask them questions because they may have some information that I wasn't aware of. So I do want that opportunity to have that interaction. So again, I don't think it's just, I have also attended some PCC meetings myself, and I don't think that that's just an adequate enough for us to make our decisions. So and we have overridden their decisions in the past anyway as well. So we do have the opportunity to do that, but at least another meeting besides the PCC meeting seems to be in order.
Thank you, Sherry. And I think that's the beauty of this discussion, because I wanted to say the same thing. That's something that I didn't even think about. And it kind of starting to make sense to me. So thank you, Frankie, for that suggestion. All right, everybody that had a chance to speak, I'm going to go round two. And remember, this is just a discussion, and we will dive even deeper if we have to on the 14th. So I have Dan and then Jackie. Mr. Butler.
Thank you. So one thing is I have a problem with anything that's proposed that we don't know who proposed it. Because this sounds like an administrative thing, or maybe a few people just don't want to get their hands dirty. You hear a misleading statement that comes out. A question is asked about that statement. It's answered, and the same misleading statement comes back again as if it wasn't answered. There should be the ability, we're assuming that all these board members who were elected by the public don't have the ability to separate facts from emotions. And we've already stated that that can be done. So why we keep covering that same ground, saying that it's putting it in jeopardy and, it could create problems because people might hear things and they're, I don't understand that. The other thing is, you say that this is done in other counties, right? Where they have just the one meeting,
Yes.
right?
That's-
All the other counties,
what I-
how many counties do they do it in?
What I said was, that is what I've heard. And I know what the statute says.
The executive repeated it.
What the statute says, it requires, that's all it says. It says one PZC meeting, public hearing.
Okay.
So it doesn't particularly matter whether it's done otherwise.
And before I continue on that, the public, when they come, they can present in the public hearing evidence
Correct.
that can be heard. So it's not all just feelings or conjecture. It's actually evidence. We had
100%
experts
that.
come in and stuff. So it is important for us to be able to hear that. One difference between our county and the other 98 is that we're an executive form of government and they're township. So the way they handle things, they've got 5 different people that kind of handle different divisions. Where here, we all handle everything. So it's a little different. So to make that comparison is I don't agree with it. To just say, oh, well, other counties do it. We're different than all the other counties. And I believe it is our responsibility as elected officials to hear this at the county board meeting, everything that's entailed. And I know it can be hard. I mean, when the quarry came out, I went to all their houses and I listened to all their stories. I went to both sides and then I voted against it. And then I had to answer all the emails to why I did, because I said, here are the facts. This is why I made my decision based on these facts. And that's what we all have to do. So I don't know, maybe we should switch back to a township style of government and it'll compartmentalize and then not as many people will have as much work. But that's, not a good comparison in my opinion. If we're talking about 2 hearings, it makes sense that the one meeting where everybody's going to be there would be at one of the hearings. So I don't understand why we would have 2 hearings at 2 committees where not everybody would be there. It makes sense to do it at the one meeting where all members come together to hear that. Let's see. Yeah, well,
All right.
that's all I have.
Thank you,
Jim.
Dan. I just want to add my 2 cents. My hands are not dirty. I'm ultimately in charge of this agenda on the executive committee, and on the paper copy, my name is listed under this discussion item. So I'm taking full credit for bringing this to the executive committee and having this discussion.
That's not what was implied.
All right.
I meant people making decisions when
Also-
500 people come into the room and they don't want to have to make the decision. That's what I was saying.
Okay, misunderstood then. Also, if, we could do away with all committees and we can just have a full board meeting and run through every committee if you want the entire board to sit and listen to every single issue on every committee. So I don't know what make land use any different than public health and safety or transportation. If you want us all here, we can do it all at once. So second statement, Jackie, do you wish to speak?
Mr. Speaker, yes, I have some questions, and I want to say that I interpreted what Mr. Butler said exactly the same way you did. And I did see your name on here. So, questions. I have noticed that we do things completely different than perhaps a municipality. And I'll just give an example. In the village where I live, they have a planning and zoning committee. Those members will not speak to a member of the public, ever. I actually contacted one of them who I know because he used to work here at Will County. He refused to speak with me. He did not return my phone call or my email. They are very careful, apparently, about who they communicate with. They want to make sure that the evidence that they take into consideration is in the hearing room, right? So that everybody gets to hear it all at the same time. I felt very pressured, badgered, almost stalked by people during this quarry conversation. And I don't think I'm alone in that. I am very much looking forward to next Wednesday, because being here 17 years, no one's ever sat me down, not even before I was on land use or after, to explain to me what my responsibility is as a board member, what I can listen to, what I can't listen to. I do like Mr. Pretzel's idea. I think it should take place in the land use committee if we're going to have a public hearing. I don't know if that's legal.
I'm running it through my head, trying to.
I saw you
Yeah.
kind of doing that, so.
So certainly, Mary and Matt and a few other people in our office will run this through before that meeting, hopefully on the next
Okay.
Wednesday.
Because I would really like the answer to that question. I would like the answer to, as Member Ogalla brought up, yeah, we have a responsibility to meet with our residents when they have a concern. But again, how do you separate what they tell you and maybe even what you know? I've lived in Bolingbrook 53 years. I know stuff about that town that no one else in this room knows. And do I take that into consideration when I make a vote? How do I not? How do I not?
Would you like an answer?
No, not.
Yeah, I would say
Rhetorical.
This is a rhetorical question. I don't.
It is very rhetorical.
Yeah.
I'm very much looking forward to the answers next week at the committee of the whole, whether or not we can do this at the committee meeting. I agree with the committee process. By the way, counties that follow the township form of government also have committees. I know it's a novel concept, but they have committees too that make decisions before they come to the full board. They operate very similarly to us. The only difference is they take on more issues because they don't have a county executive that handles a lot of the stuff. It literally is all done in committee, and they follow that committee process. I wish that our board would get more on board with the committee process. So thank you very much.
You're welcome. All right, two more. Sherry Newquist.
Thank you. I think, and this is one reason why I'm so on the fence about this, I think that one of the issues that we have, which ultimately results in people wanting to present at the full board meeting, is, think about it. It goes to PZC. If PZC vote, they can vote 7-0 against it. It still goes to land use. At land use, we could vote 7-0 against it, and it still goes to the full county board. I've never actually understood that, but I think that's why in a lot of people's minds, first of all, people are shocked when they hear this. They think if PZC shoots it down, that's the end of it. And then they think if land use shoots it down, that's the end of it. And I've had a lot of people make comments to me like, oh my God, we've been to these 2 meetings and now we have to go to a 3rd meeting. So I think that is part of the issue that we have with people wanting to present evidence at the full board meeting.
Thank you. And Ms. Hickey.
Thank you. So I feel like I'm almost contractually obligated to say, and Dawn does too, that we're new. So I want to get that out of the way. So I do want to just make sure that I'm understanding this. None of this would absolve the county board from actually having to take a vote on an issue. Okay.
No, for the record, no. Sorry,
Yeah,
I
okay.
shook my head there.
Okay, thank you. If we took, I guess we can take,
Yes.
yeah. So if we go to PZC as a board member, we are only allowed to ask questions as if we were a member of the public, right? I mean, it's going to be limited in time in some way or,
Correct. The adjudicatory body there is the PZC. Those members would be the ones conducting the questioning.
okay. I think that a part of this is there seems to be, at least in how this board conducts itself, a little bit of a hesitancy or distrust in what happens in committee and how that is brought to us. And I think that it would be great if part of the discussion on Wednesday is kind of, you know, how that actually weaves into all of this. Because, you know, I would love it if we could have the discussion at committee and have the committee spend their time and attention on something and then trust that information when it comes to the full board instead of having to tear it apart ourselves and start over. But I just think that that idea is kind of interwoven with some of the concerns here. So.
And certainly if there's anything that, that even outside of this public hearing aspect that you guys have questions about with regards to the land use process, myself or Mary would be happy to take the email so we can do the research ahead of time and get you a better straightforward answer. The same with the FOIA portion. I know I certainly will appreciate because I'm going to do it. If you have any specific hypotheticals that, you know, this doesn't make sense with you, it's a little more advanced than just reading the statute, go ahead and send it over to us and we'll try to get that answer researched and done by Wednesday.
Right. Thank you very much. I appreciate that.
All right. Well, thank you
I-
everyone for the discussion.
I have a parliamentary inquiry.
Okay.
So at the PZC, when they have their public hearing and then they take a vote, it's a recommendation, right?
Correct. The final decision is always made by the board.
So when they have,
They vote on variances and those don't, and that's what I kind of.
I'm just
earlier when I said
asking
I didn't
for-
want to go through all the different things. Variances are different than special uses versus map amendments.
so is it required at a public meeting before the board that there be a vote that is an actionable item when they have that second meeting? Because at some point before they approve that special use permit, is it required to have a public hearing?
I'm not sure that I understand the.
Like at a committee, wouldn't that just be another recommendation?
Right, and I believe that's how the land use,
So
land
do
use
two
recommend-
recommendations going to the board
Yes,
instead of the board hearing that and actually making a vote? Here, at the end of a public hearing, the board actually makes a vote and it becomes more than just a recommendation. It's an actionable item.
right. Under your zoning ordinance, the final vote is the more than the recommendation. So we would also, as part of some of these ideas that have come forward, want to look at how other parts of the zoning code would need to be amended to accomplish those goals.
So there's just a little bit of, we just need a little more clarity on how a executive form of government would handle this as opposed to a township style of county government.
Sure, we can look into if there's any difference that makes a difference in those two forms for these purposes.
Okay. All right. Thank you, everyone. Committee, non-committee members for giving your opinion. Discussion item, more to be heard on Wednesday. Kevin, thank you very much for your unbiased opinion. All right. Let's move on. Number 4 on our agenda under new business, designating Midland Federal Savings and Loan as a county depository. Attached complete list of county depositories. Discussion? We do have a clean roll, I believe. So all those in favor, please say aye. Aye. Anyone opposed? That motion will carry. Number 5, an ordinance amending Chapter 41, Purchasing Code, Section 41-.004, definitions, and creating a new section establishing location preferences for public works projects. before we get started on this, we do have a responsible bidder ordinance already. This is something that I had brought forward to our county executive and our county board chief of staff, something to look into. And the purpose of this basically is to try to give more projects to the local bidders. I want to, you're looking at me weird here. Okay. Okay. So the ordinance was written, there is a red line version. For some reason, it did not make it onto our agenda. But basically, there's some bids that are coming in through our public works and projects that we want to do. And it seems like there's a possibility that they are using AI technology. These bids are coming in extremely close, within dollars of each other. This will give us the opportunity to take a deeper look and try to hire the contractors that are local. Chuck's passing them out now. I know you might not have enough time to read, but does anyone have, let's open that up for discussion. I seen Jim, I'll go ahead and go with you, and then I'll go with Jackie.
All right, so quickly, I wanted to define local. Is it Will County? Is it Illinois, Northern Illinois? And then the other question too is, when you say preferential treatment, does that mean that they could be a higher bidder? And what would that, what's that delta or that we are looking at?
Yeah, I shouldn't have said preferential. I should say it gives us the option to not only take the lowest responsible bidder, but possibly the next responsible bidder if they're within 50 miles, I believe. Is that correct? So the radius is not just Will County, but within 50 miles.
So that could include Chicago all the way down to, I don't know, Pontiac or something like that, or I don't know, kind of a big circle.
Yeah.
But so let's just say, and I'm just, because I'm trying to wrap my head around this. Vince is in Pontiac. I'm in Will County. I bid $105. Vince bids $100. Who wins the bid? Because obviously there's going to be a cost delta there. Now I'm closer, but I'm going to have a negative impact on our budget overall. And if we do multiple bids like this, it could actually be tens of thousands or much more than that even financially.
I don't have the answer to that.
Okay.
That's a lot of legal.
And I didn't get a chance to read.
Yeah, legal stuff that I'm not qualified to talk about. I guess my ultimate goal was to try to present this to the board to try to give our local hands, an upper edge on, working in Will County, from Will County or the surrounding areas. Let the taxpayer dollars stay here, within the 50-mile radius.
Understand, I
Yeah.
appreciate that, but I mean, sometimes you look at some of these contracts, what they do, I don't know whether you want to call them set-asides or preferential treatment or that, where it could literally cost 10, 15% more for a project. And with a budget our size, that could easily, cost us millions of dollars, maybe not tens of millions.
This was just an idea, and I think Mr. Mahoney is versed in this kind of subject to try to address that particular question.
Right, thanks.
We'll answer that, and then I'll go to Jackie for her question.
Thank you, Speaker, and thank you, Leader Richmond, for the question. So the way this is drafted, it would be if the county so chooses in a bid, they can use a local preference credit of up to 3% within a 50-mile radius of the county located within the state of Illinois. So this would, in your example given, Pontiac would be within 50 miles of touching the county, so it would still qualify and you would use the lowest bidder at that point in time. Most all of our bids come from within the state of Illinois. This just provides us the option of doing a local preference in case we were to have large scale projects that solicited bids from further than downtown Chicago.
So this goes back to last year, Mike. We had 1 month where we actually had all the bids and the information and all that. And I'd say as of December, we haven't gotten any more information. And I believe the gentleman's name was Kevin or something like that.
Kevin is our
Can-
purchasing director.
If we're going to start, what I'd like to do is I'd like to see us start getting that information again. Because to your point there, 3% of, could be a substantial amount of money.
And there's a maximum amount, it would only go up to $100,000, which seems like a lot of money, but that would have to be a very large bid to go up to $100,000 and change.
Yeah, about a $3 million project, yeah.
And so, as the speaker was saying, this also provides the county an option when there is ties. And we are seeing this more and more as bids come in. People go and measure square feet. What the project requires, throw the scope and what we're assuming to be a pricing software. We've had bids come back on a couple $100,000 projects within $5 of each other. We had bids recently that were over $2 million projects that were identical. And so this then gives us the ability to start using one local preference, and also allows, in case of ties for lowest bidder, it codifies an ordinance that we have the ability to technically flip a coin instead of having to choose, which then exposes the county to liability.
Okay, yeah, so if we could maybe start getting that bids and, winners, whatever you want to call it.
And
tab sheet
that's
that-
all posted online, but I can gladly get that over to you.
Yeah, well, he did put together a nice spreadsheet back in
Yep,
November.
I
so
will,
if we could
I will
consistently-
check that and get it updated for you.
Thank you.
Jackie?
Thank you, Speaker Van Dyne. Yeah, Mr. Mahoney, I know you had mentioned this to me before, maybe a year ago, maybe longer, I don't recall. But my question was going to be, what's the concern about AI? But now you've kind of elaborated a little bit. You're concerned about people using the same software program to do the bid based on square footage. That package would come up with basically potentially the same price.
In Member Trenier, it was a $2.2 million bid, and
Yeah.
the dollar figures were identical from two different companies.
Yeah.
And so
It's,
it puts us in a little bit of a box, but then creates some urgency to try to get something on the books where, in case of a tie, because more and more is scopes from our office get more detailed going out, they're able to just feed that into what we assume to be a pricing software, because otherwise it doesn't make any sense as to how tie bids or bids within
how
$5
it's
are
so
coming
close.
back. Yeah.
Sure, no, and I owned my own company for 18 years, and it was kind of interesting. When we didn't want a job, the price was really expensive. And that's what I've always seen on the Forest Preserve. And I had actually asked the director, he's still technically the director, about it at the time. I'm like, why this big discrepancy? And then he said, well, they obviously didn't want the work. And I said, oh, yeah, I know what that's like. I'm not used to seeing bids that are like so extremely close. Do we have a process now, in here, I know it mentions flipping a coin. Do we have a process now?
In case of a tie, no.
Okay, and then and maybe I'm lax on doing my job as the new chair of Public Works. At the Forest Preserve, we always receive the chart of all the bids in our packet, and I don't recall seeing charts like that. We get a final bid put in front of us, and we're asked to accept that bid, and we're just assuming in committee that that was the lowest bid, because we don't get the results of the entire project. Is that normal for Public Works?
Yes. Yeah, we have all the documentation. Obviously, it's all posted online, but we just don't include it in.
Okay. Yeah, I just thought it was odd. I'm used to seeing it all on the Forest Preserve side of our job, and just,
And just as a reminder, all of our bid openings, they're all public. They're in usually conference room A, scheduled online, scheduled when the bid goes out. And so everything with that is publicly posted and available for everyone.
yeah, no, I'm so used to it kind of being spoon-fed to us that I didn't even think about the process about where I would find it. And I should have. I mean, I'm used to doing it at the township level. We had a bid that was being opened on May 1st, and it was publicly being opened, and, I assume the board will get all that information when they make their decision. Thank you. That was my only questions.
Thank you. Judy?
Thank you. So I think part of this situation that you're dealing with here is due to Senate Bill 1015 that was passed that took away the us, Jackie. it took away the county board's capital improvements committee from looking at the bids, being part of the bid process and giving that to the county executive. So that's why you're not seeing this any longer. We used to have that. And so maybe you remember that. I remember when Reagan Freitag was the chair of capital, that happened in the prior ones to that. But you keep telling us, Mike, that it is on the website. I know before, when we looked for it, we couldn't find where it was. And then while there might be a link, we didn't have access to it. So I mean, give us that, send us the information in an email so that we can see where it is on the website, how to get into it. And then it also says the bid openings are open to the public. Here's the thing, as a board member, we are very busy, and now we're talking about public hearing and maybe going to PZC or whatever, changing for that. There's more requirements by us to go and search for information. And you know our website, where we're doing our websites, because they're not easy to find things. So it would be great to have one other bid openings sent to our chief of staff. He could then disseminate it to the entire board. And if the entire board wanted to attend that public bid opening, they could do that. We've never been given that information. That's something that we've asked for. We don't have that information. I'm not saying I'd be opposed to something like this, but having this come forward and never having any proof of seeing anything, we've never seen the bids. We don't know how close they're coming in because we've not had access to that. You see it, but we've not seen it. So asking us to make a change to something we've never had access to or seen, except for hearing it today, makes it kind of difficult.
Dawn Bullock?
Quick question. I'm in a cursory glance, these look the same. Chuck, is the paper clip and the staple different in some way, or? They're both, thank you. Okay.
Different connection on them. We ran out of staples.
Gotcha. Thank you.
Sherry?
Thank you. Question. So let's say that we had two bids that came in, maybe not identical, but relatively close within, 0.5% or even 1% of each other. Is there anything in our ordinance that would allow us to, let's say one of the vendors was from Will County and the other one was from Grundy County. Is there anything in our ordinances that would allow us to select the Will County vendor, all other things being equal?
This is a very good question, and the answer is yes and no. We are lowest responsible bidder here in the county, but also if you were lowest, but you have to be defined as responsible, right? And so any projects we are doing, government money is involved. Davis-Bacon comes into play a lot of times. All state prevailing wage work comes into play a lot of times. We will have, and I'm just giving a blanket example. There was a bid maybe 18 months ago where we had, it was very close, but looking at it, one of them had Department of Labor issues with liens and ability to perform work, right? And so you are able to then look at that as a responsibility clause. So it's not an easy process. A lot of these take time and a lot of review as to who's coming in, but the short answer is yes, but often no.
Could we have something that gave preference to Will County vendors, or is that not quite legal?
That is what we're trying to accomplish here. And you're going to say that's a broad territory. We get a lot of competitive bids from Will County, but at points in time, you want to have a local preference that can also extend, as we don't have huge amounts of some of these vendors to come in. So for example, Courthouse Plaza is starting tomorrow with the sidewalk restoration, and that's a bid that came from Northwest Cook, if I believe.
Thank you.
I do remember at the Forest Preserve, we did have a low bid that was not deemed responsible, and we as commissioners went to the following bid because they did have violations, something to do with not paying prevailing wage, and so that's something, I do remember that a few years ago, but.
And Speaker, just to piggyback on that, we have responsible bidder ordinance in the books currently. This just updates it and gives us some more clarification to expose us to less liability as these procurements get tighter and tighter.
Mr. Butler?
Yeah, I missed the first part. So when you say local, are we talking just Will County or Will County and Collier counties?
It's Will County within a 50-mile radius if the county so chooses on that bid to use local preference.
Into all the Collier counties, okay.
Yep, and Illinois specific, so not going any further east.
Thank you, Dan. Micah?
Thank you. So, Mike, I was trying to read through this, and being on the ordinance committee, all things in red are things that have been added.
Underlined, added, striked out, removed. Red's where the additions and changes are.
So, section F, not sure the numbers, hold on. 41.041 bid submission requirements for public works projects. Section F has a statement about the Prevailing Wage Act. And when you mentioned that issue, but I remember when that particular issue that the chair just mentioned with the Forest Preserve, Joe, you were actually the one who brought that forward with the concerns. Would this paragraph F, would that prevent those from coming in as bid options?
Correct. Yes, so if you were found in violation of wage law, you would be excluded from bidding, and I don't remember the exact time frame on here, but
2 years, I believe.
yeah. Thank you. So 2 years. So yes, in that the county is liable when it comes to wage and contractors paying prevailing wages. We are the actual, at the end of the day, the people paying the bills on it. So we try to avoid that at all costs. It is we have done a great job keeping it from being an issue, but language like this gives us a little more teeth than what we have currently for our prevailing wage responsible bidder statute.
And I have also heard that there have been a couple instances where jobs that companies within the county could have easily done within like $1 or $2 were outbid to somewhere else, and they weren't real happy about that. And that would stop that as well.
This would allow a local preference, right? So if we had somebody from Rock Island bidding, we would be able to say, hey, we would like to keep the work closer to use our tax dollars locally.
All right, thank you.
Jackie, additional comment?
Yeah, I just had another question. So I did find the section on the website. I will say I am kind of curious about how often it's updated because I don't see anything here about the sidewalk project, and there's absolutely nothing here for Public Works. And again, I don't think we ever had those attached to our Public Works agenda, even before Senate Bill 1015. I don't know why, and I'm just curious about the process since you're bringing it up.
Yep, and so our purchasing department handles what we would call capital projects outside of transportation. And so sidewalk at the courthouse, that will be updated once the project gets to near completion, I believe. I'm not sure on that one, maybe sooner. I will check in on that. Don't quote me on it. For transportation, that is all handled within Department or Division of Transportation. I should
Different
say.
website.
Totally different website. Eventually, those will all be merged together, but that goes exclusively through Jeff's shop.
Okay, and then there's this section right at the very top that says Demand Star bids, and then it says Demand Star subscriptions. I've used Demand Star. It's funny, I feel like it's changed names, but they still call it Demand Star, so it made no sense to me. But, and then it says Will County bids. Can you maybe tell me what those three things mean, or is that a better question for Kevin?
I will give you an answer. If I have any follow-up, I will go talk to Kevin and get you an answer later today. But Demand Star is what, if we wanted to do a solicitation further and wider, we will go to that route. So this board approved a Medicaid consultant for the nursing home and health department. Once we get that finalized, that will be a Demand Star bid that will be spread out. And so a lot of consultants can see that. We have some other projects where we can bid it locally. We have a pool of people that we know will bid on the project. We will have a list of 100 email addresses to send it to, and we would call those Will County bids.
Okay. If I click on this, am I going to see all the current bids? Is that how it works?
If the website is working, it should.
Yeah, that was kind of my question. I just wondered, because what it brings me to is just the website for Demand Star, which doesn't really give me any information about any of our bids. It's just the website for Demand Star. And I assume in order for me to see anything, I'd have to log in, and I don't have that for the county. I had
Correct.
it.
Now, everything that we do on Demand Star is posted on our website too. It's just Demand Star has an alert system that sends people
Okay,
for
so
their,
if I want to see the bids, really what I want to do is look at the Will County bids.
that should be it.
Okay, all right, yeah, I am starting to
That's
see
the
that.
need for a new website, which the
Yeah.
RFQ will be going out. It's at the state's attorney's office as of last week.
Thank you. I probably should have asked these questions years ago, but it just never occurred to me. Thank you.
Okay, Dan?
So I just, I'm just going to say it now. I oppose the 50 miles. I believe Collier Counties is enough. I don't know why we came up with 50 miles. I think that just brings the city of Chicago in, which could have plenty of bidders to come against our people. But I might as well spread it out all the way across the Collier Counties to give everybody a shot. So that, I'd like to see that changed.
You raise a very valid point, and we wanted to have a preference where we had work that would be considered local, and don't just view it as going to Chicago. It goes south to Pontiac as well. But you also want to have a preference option that for a county of our size allows you to still be competitive if you so choose to go the preference route. Cook County, for instance, they do a local preference, and the local preference is specifically Cook County derived businesses. Now they just have 7 million people to choose from, and we have 700,000. So you want to be competitive, but still have the option to retain local preference.
Well, that's a good point because, you know, with those 7 million people, I mean, and all those extra businesses, of course, they could have way more bidders against the project than we can. So I'm just saying, if you really wanted to make it competitive, maybe cut that part out and make it just more rural, you know? But I think to be fair, the whole Collier County, you know, certainly even with complete Collier counties, you won't compare to Cook County or Cook County as far as how many bidders will be able to come against our local people here.
Okay. See no other discussion, so we do have a first and a second with a clean roll. All those in favor, please say aye. Aye. Is there anyone opposed? We got one opposition. Motion carries, 8-1, 10-9-1? 10-1? 10-1? Fair enough. All right, thank you. Number 6, resolution supporting dissolution of Southeast Joliet Sanitary District and the transfer of its assets and liabilities. Motion Ortiz. Thank you. Second Williams. Questions, discussion? Is there a previous? Second Hickey, Mr. Butler, would you like to be a yes? Okay. The resolution is supporting the dissolution of Southeast Joliet Sanitary District and the transfer of its assets and liabilities. Okay, so
Just a question. So we're getting their assets, their liabilities. I'm assuming this is a taxing body of some sort?
yeah,
Do we get the taxes
can I thank you, Elaine, for coming up.
or do we just take over?
She would be more than happy to explain this.
Yeah.
Thank you for the question, Member Turnier. So Southeast Joliet Sanitary District is technically a taxing body, so they are able to levy a tax rate. However, they historically haven't levied a tax rate. Their primary source of income for their provision of services is just through bills alone. So by the Southeast Joliet Sanitary District dissolving, it is thus the elimination of an additional level of government and an additional taxing body.
I understand that, but I just want to share my experience. We eliminated the mosquito abatement district that's over in the Romeoville area. And I guess Romeoville then took on the responsibility for it. And the first thing they did was come to DuPage Township and ask them to pay for it. So we aren't really eliminating anything. We're just passing the buck. There's going to be a cost to this, right? So we're going to absorb the cost for eliminating a local unit of government. I just want to make sure everybody understands what we're doing. We're picking up a responsibility, a financial responsibility without gaining any money. So in effect, I guess we're saving the taxpayers' money at the expense of other projects that we do.
So if I can add some additional clarification.
please.
So this has been a process that the county has been working with the Southeast Joliet Sanitary District as well as the city of Joliet. So the city of Joliet is ultimately going to be the entity that goes ahead, takes over the provision of water, making sure all the upgrades are going to be allocated. The portion of the county contribution, there is CDBG funding that is going to be allocated towards this project to ensure that there's access to quality drinking water and safe sanitary conditions. And then there was some initial ARPA funding that was dedicated to the low flow toilet rebate program.
Yes.
But if this fully goes through, the idea and the intention is to reallocate those ARPA funds instead of low flow toilet rebates to making sure that the residents have upgraded infrastructure that aligns with City of Joliet's needs.
If we're going to use ARPA dollars, are we going to have them expended by the end of the year?
We've been working closely with our ARPA consultants and they've been up to date on everything. So I believe we are all set as long as everything hits the
All right.
marks they need to.
That's the only thing. I just wanted to protect our levy from increases that we weren't anticipating. Thank you.
Judy?
Yeah, I have a question. What kind of dollars are we talking here, Elaine?
Yeah, ultimately for the whole system, so this is a big number, right? So this is not just in 1 year, this is not one go, long term. To bring the system fully up to the standards that City of Joliet needs to operate and have it switch over to Lake Michigan, it's $14 million.
Mhm. And that would be covered by the city of Joliet?
So it's going to be a combination. So it's the ARPA funding, it's CDBG, and then we have some additional grant funding as well that the county has received.
So we're able to change the way we're spending ARPA dollars at this point and reallocate them towards something else?
I don't want to say that we're changing the usage, right? I mean, it's still within the same spirit of what the funds were originally allocated for, which is the improvement of water and all the other.
So still within the same pillar?
Correct, yeah.
Still within the same pillar, just removing it from the Southeast Joliet Sanitary District, which the money was given to before via ARPA?
So the money was initially allocated over towards our land use department under community development. So it was going to be our community development department that was going to oversee that as kind of a grant program.
Okay,
Mhm.
all right, thanks.
Micah, and then Sherry Newquist.
I hate to bring this up, but you said part of the funding is coming from the CDBG.
Correct.
Is that already in the budget? Have we already got our hands on that money at this time?
At this point in time, we're going through the process, right? So CDBG goes through, they have their open call for applications. They provide a recommendation. I don't believe that final recommendation has been voted on, and we do not have our final totals of what funding we're going to receive. But there has been a set aside for this project.
And just so I'm sure this is the Community Development Block Grant.
Correct.
Which our current President of the United States, Mr. Trump, President Trump, he is cutting that program. So is there going to be a problem with that?
I don't feel qualified to answer that question.
Because it says the budget
Nobody here can.
is proposed to eliminate the CDBG program, and for relying on funds for that, that could be an issue. So that's just what we got just the other day, so.
Future
So-
times.
I was just curious, thank you.
Sherry?
Thank you. I just want to clarify something. So I'm looking at the resolution. I'm in the fourth paragraph, number 5. And number 5 talks about, Joliet, the city of Joliet taking over the assets, but it says, number 5, that the county of Will shall take responsibility for and control over assets deemed unnecessary by the city of Joliet. Like, what does that mean for us?
Yeah, so I will give you the real life example on this, right? So we've been in conversations with Joliet of what their responsibilities are going to be, what they're going to do within this process. The district itself has assets. They have a water tower. They have a abandoned sanitary district place that would just be the land, right? They have a home that's been converted to their office buildings that is considered part of their assets. City of Joliet does not have an interest in the home that they operate their office out of, right? So Joliet said, look, we don't want that. Can we figure out kind of what the plan is with that? So this is written with the ability for Joliet to say, oh, no, you know what? We actually do want to take over the house. We want to keep the truck that they have. So if Joliet says, hey, we're interested in keeping this, great, they get to have it. If Joliet says, no, we don't want to deal with it, that asset then would become the property of Will County.
Jim?
So 2 questions, Elaine. Does this cover all those houses in Joliet that we've had discussions about that have had? No.
No.
Okay. All right. What is the exposure still of housing in Joliet that doesn't have coverage? And I know you may not have that answer right off the top of your head, but that'd be something we should understand. Second off is what's our potential exposure if the CDBG dollars are not moved forward? And is that exposure going to be borne by the Will County residents as a whole?
I don't want to guess as to what's going to happen with CDBG, right? But
There's no need to guess on
right.
CDBG, but let's just assume they get cut.
so
What's our
assuming
exposure?
it gets cut, the county would continue to fund the program. So it would be,
To what dollar amount?
I came with everything except for that.
That's a big piece of the puzzle.
Correct. I don't have
And
that
I'm
right
not
in front
against
of me,
people
but I
getting
can get-
water and sewer, that we just need to know what our exposure is. I mean, to make a decision without knowing your exposure is probably not the best way to move forward.
Yeah, I apologize. I don't have the CDBG funding amount.
When would
right
you
in
have
front of
that?
me.
When would you have that?
I could have it in like 10 minutes.
Perfect. Thank you.
I doubt we'll be here, so just kidding. Denise?
Thank you. And I'm not on this committee. I'm just speaking up for those people in that section since it happens to be my district. That is the Preston Heights, Sugar Creek area just south of the city limits of Joliet along Chicago Street. Part of that is already annexed to the city of Joliet because they annexed to do the racetracks and things along there. So this branch is directly off of there. That sewer and water system dates back to 1951. It has been patched and pieced together from that time until now. They do not have anything other than, well, this is an area where they consistently have boil orders, do not use, those kinds of things. The project's going to be very similar to the one, for those of you who are familiar with it, the Ridgewood project, which we did a few years back with a combination of funds, a lot of it being CDBG, in order to put in sewer, water. In that area there, they had raw sewage on their front lawns. This isn't as bad as that. They don't have that, but they do have consistently boil orders, do not use next. Sometimes that goes for days. So it's a much needed project. It is right at our Southland, and it's also an area which could, with the new sewer and water systems, be more appealing for people who are newer homeowners and people who are looking for places to work closer to all our intermodals and things like that. So I'd encourage us to support this.
Okay, with that being said, I don't see any lights are on, and I believe we have a second previous roll, so I will call all those in favor, please say aye. Aye. Anyone opposed? Okay, we do have one abstention. Mr. Richmond. Okay, very good. Number 7 on our agenda, authorizing the county executive to execute an IGA with the Village of Shorewood to provide access to the countywide radio system. Mr. Richmond, would you like to be a yes on this? Number 7 on our agenda. All those in favor, please say aye. Aye. Anyone opposed? That motion carries unanimously. Number 8, authorizing county executive to execute a tower site lease agreement for the use of the radio tower site owned by Tower Sites Incorporated. All those in favor, please say aye. Aye. Any opposed? That motion will carry. We have no other new business to discuss, as far as I know. We do not have a request for any state's attorney's opinion. Sometimes we like them, sometimes we don't. Under committee reports, does any committee chair or vice chair have a dying need to give us an update on their committee? Okay, very good. I include ad hoc as well, but I believe we already spoke about that. Executive Committee, we just completed. Moving on to appointments, there are 4 items listed on our agenda. The first one has 1 member, and I can refrain from naming names. They are printed, though. Number 1, approving appointment by the county executive for Manhattan Fire Protection District. There's 1 member. Is there a motion? Speak up. All those in favor, please say aye. Aye. Anyone opposed? That motion will carry. Number 2, approving appointment by the county executive for Agricultural Area Committee, which happens to be one of our members. Is there a motion? All those in favor, please say aye. Aye. Anyone opposed? That motion will carry. Number 3 has 6 members. Approving appointments by the county executive for CDBG. I have to say it slow as well. Home Advisory Board. Is there a motion? All those in favor, please say aye. Anyone opposed? That motion will carry. And lastly, 1 member approving appointment by the county executive for Bonnie Bray Forest Manor Sanitary District. All those in favor, please say aye. Aye. Anyone opposed? That motion carries. Is there anyone from the public wishing to speak? Seeing none. No announcements or reports by the chair. No need for executive session. Okay. Motion to amend the county board agenda as follows. Finance Committee, items 1, 2, and 4 will be moved under the consent agenda. Public Works and Transportation Committee, items 1 through 13 moved under the consent agenda. Capital Improvements Committee, item number 1 will be removed because motion failed. I want to add all the items approved today at Executive Committee. And I also would like to add the executive session minutes from 4:17. So I need a motion to approve the county board agenda as amended, or the amendments first, please. Trenier? Thank you. All those in favor, please say aye. Aye. Anyone opposed? That motion will carry. Now I'm looking for a motion to approve the county board agenda as amended. All those in favor, please say aye. Anyone opposed? That motion will carry. Our next scheduled meeting is for June 12th, 2025, and I would love to entertain a motion to adjourn. All those in favor, please say aye. Anyone opposed? We are adjourned. Thank you.